Immigration attorney Sharifa Tharpe. It's good to see you. I'm back to talk about a very important topic today and also to answer your U.S. immigration related questions. Go ahead, putting your questions in the comments now. And as soon as I finish talking about the topic that I'm here to talk about, then I will jump to start answering your questions. But before I start, I want to put something to you. Now, since you have been in the United States, can you think of a time where you have been the victim of a labor violation? So, has an employer ever mistreated you? If you want to share, go ahead and just you can put in the comments maybe something that you experienced. Was it that the employer refused to pay you? Was it that the employer called you names? Go ahead, put those your comments in to tell me what your experience was like working for an employer in the United States, especially if you were working for an employer and you did not have your papers. At the time, you may have your papers now, you still may not have them. That still may be your employer, but may not be your employer. But please let me know if you want to share some of the worst case scenarios that you have experienced working for an employer here in the United States. Now, I'm curious because there is a new measure that the Department of Homeland Security has implemented. Hi there, Caroline. Nice to see you. They have a special program for individuals who have been victims of labor violations in the United States. They're trying to crack down on employers who have mistreated their employees and maybe not even have mistreated them in the way that we're thinking, right? We're abusive, maybe call you names, but where they have taken advantage of individuals, they have exploited them. They have, for example, not complied with wage and hour. They have maybe tricked the employer into thinking that they had to work when they didn't. Maybe they cheated them out of minimum wages. Maybe the employer went ahead and did not pay overtime. So these are some of the types of violations that could potentially get you an immigration benefit. Now, the way that we have to submit these requests, so this request for immigration benefits, is it usually first has to be reported to an agency. And the agency is likely going to be the Department of Labor. They do have the wage and hour division, and they have other divisions that look into other types of labor violations, just depending on the type of violations. This is something that I do on a regular basis in my practice. Now, what I do, this is a new measure that has just been implemented called deferred action for those who have been the victims of certain abuses or labor violations like wage and hour violations. If you're stiffed out of your pay, if there was wage theft, meaning they owed you your wages but did not pay you, or they were supposed to pay you overtime, that would go to the wage and hour division. And I do work with even more severe situations where it not only involves wage and hour violations, but it also involves a form of labor trafficking. And labor trafficking comes in different forms. But I do work with the Department of Labor on these types of situations because you are required to work with the Department of Labor in order to get approved for the work permit for the T visa, which does lead to permanent residence. That has always been there. It's called the T visa. However, there is now a new program in place called the action. This does not lead to a green card, but it can still bring much needed relief to individuals who need a work permit. They need protection from deportation. And this would be the way to go in that regard. This was just announced maybe a month ago. And so it's brand new, but based on my experience with the T visas, I am very much aware that this is a valuable benefit because clients that don't necessarily qualify as labor trafficking victims can now apply for this because this deferred action, not it doesn't require you to be the victim of labor trafficking. It does require that there be some interest by the Department of Labor or some other agency who's in looking into the labor violations, and as a result of that, they provide deferred action. So they do want to see evidence that maybe this has been reported, that you are seeking your wages or your back pay, or you want some sort of um, you've reported it and you want you need something out of it, like what you've earned. And so this is what the deferred action is there for. You don't have to be the subject of abuse, even though abuse does count because it's the law to for employers to abuse their employees, right? So, I am curious about what kinds of abuses, what kinds of exploitation you have faced. Have you been deprived of your pay? Have you been overworked? Have you been underpaid? Have you been deprived of overtime wages? Of labor violations have you experienced? And do you think that it was partially because of your immigration benefit or lack of immigration status or lack of immigration status? So now that I've explained to you what the deferred action is, so deferred action, just to be clear, deferred action, this is the benefit that you get if you've been the victim of a labor violation and you've reported it. Deferred action provides you protection from deportation. It puts you in a status where you no longer are accruing unlawful presence, because every day that goes by that you don't have your immigration status is another day added to unlawful presence. And so this stops unlawful presence and it allows you to get a work permit. Usually, when they do grant deferred action, they grant it for 2 years. This is usually the when you do get this deferred action, it buys you time. So, for example, for my client, it's very valuable in that it can buy them time while they wait for their T visa. But even if they don't qualify for the T visa, in 2 years, they're protected from deportation. There are other ways to be able to gain status that now they can explore those options. And since the deferred action stops unlawful presence, if you have been here for under 180 days, so that 180 days hasn't passed since you have lost your immigration status, that means it prevents you from accruing unlawful presence that would make you inadmissible or barred from entering the US again. So it can do some good in that it does stop you from getting into accruing more unlawful presence under immigration law that can lead to some problems in the future should you want an immigration benefit. So now that I have told you what those benefits are, go ahead. You are free to share with me if you've been the victim of any kind of labor violations, or if you're curious about what's involved in this deferred action relief, and even in the T visa. Now, with the T visa, it's different. It's slightly, and it can be related. With the deferred action, you don't necessarily have to be the victim of labor trafficking to get deferred action. So if you have been the victim of wage theft, where they refuse to pay you the wages that you earned, then that's a labor violation that can be reported to Wage and Hour, and they can get that for you. They can recover that for you. while you are working with the Department of Labor to sort through that and to get the money that you've earned, you can then get deferred action to be able to stay here, get protection from deportation so that you can get what you've earned. Now, with labor trafficking, it does go a little further, and this is more common than you would imagine. With labor trafficking, it doesn't mean that they have you tied down somewhere in a basement and then they, pull you out of the basement when they need you to work and then put you back down in the basement. Even though that does happen, believe it or not, there are situations where you could be coming and going out of a labor trafficker's workplace. You're free to leave on a daily basis, but you're not necessarily free to leave the work. As in, if you say you threaten to leave, or you tell them that you want to leave this job, and they say, well, if you leave this job, I'm going to report you to ICE. So they version, a form of manipulation to get you to continue to do the work that they want you to do. If they abuse you on a daily basis, make you feel worthless, if you find that they are threatening your reputation, they are threatening your future, right? Or they're threatening not to pay you your wages, or they don't pay you your wages to get you to keep working in hopes that you'll get your wages. This is more on the side of labor trafficking, because the employer is using a tactic or a scheme, a pattern to keep you working for them. And even though maybe one day you got up and said, I quit, and you walked out, that still could be labor trafficking if you experienced all of that before you just got fed up and said, I am gone. I don't care if you call ICE. I don't care if you come after me for the money that you say I owe you. I'm leaving, right? So even if you ended up leaving on your based on your free will, but before that you experience abuse, name calling, threatening ICE, maybe promising you that they can get you your papers and dangling it over your head and say, if you leave, you think you're going to get your papers. If you leave, you're not going to get those papers again. That is a form of coercion, and it is a form of labor trafficking. So if you've experienced situations like this, you not only can qualify for deferred action, where you get 2 years of protected status, which can be renewed, by the way, but you can also get the T visa that would allow you to get 4 years to stay here in the United States, where you would be able to, and then we can ask for forgiveness if you've crossed the border without permission, or if you've had past immigration violations or even past criminal conduct. We can apply to get those forgiven. And once those are forgiven, you're granted the T status. You can then move on to get permanent residence. There are ways, usually, you have to have the T status for 3 years out of the 4 years before you can apply for permanent residence, and you can stay here in the US and apply for permanent residence. However, there are ways to apply for this even earlier, to get your permanent residence even earlier than the 3 year wait time. So if you're experiencing anything, my rule of thumb here is, if you're experiencing any labor violations, any abuses by your employer, then go ahead, give us a call. Let's evaluate what's going on in your situation and determine whether you can pursue the deferred action, or whether you can pursue the T status, or both, because sometimes they are related and you can qualify for both right now. And right now is a good time to apply, because this is a new program that they implemented, because they want you as the employee to feel safe, right? Doesn't matter that you're out of status, doesn't matter that you don't have an immigration status right now. It does not matter. This deferred action is for individuals who have experienced these things and they don't have their immigration status. Now, I'm going to quickly go through questions, and then I will come back tomorrow as usual. So Mondays through Fridays, around lunchtime. So 12:15, I'll be here to answer questions and bring a topic. So tomorrow I'll be back to bring a topic to you. So would it be a labor violation if the employer doesn't give a day off? Absolutely. Now, when it comes out, it depends on what the situation is. What are your work hours? How long are you expected to work? I have had situations where employees were forced to work 24 hours a day, 7 days a week, as if they were slaves. So this does happen. And so it could potentially be a labor violation. I would definitely want to learn more about what you're experiencing. You can always give me a call, schedule a consultation, and we can talk about that. Now, keep in mind that I am not a labor attorney, right? And some of these things, while I deal with the immigration side, I have learned a lot about what types of labor violations to look out for. Some things I do also have to refer to a labor attorney to confirm whether this is a labor violation. But I would want to hear more about this because not getting a day off is definitely a red flag for some sort of labor violations going on here. If someone filed an extension 7 months ago, haven't gotten a response from USCIS, but got married recently and started the green card process, will the extension affect the filing? So, not necessarily, right? But at the same time, this is where it's very important to make sure you get legal advice because what's in the extension? What did you represent in the extension? That is also that may, what is in there and what presented to the immigration service for the reason for the extension can certainly come back to affect the green card filing. So that's where go ahead, schedule a consultation. Let's talk more about the extension, especially since it's still pending, just to figure out what's going on and whether the what's in the extension can potentially clash with the filing. Um, All right. Keep putting those questions in the comments. I'm going to quickly go through. I'm just scrolling through. So I do see some here on YouTube. How long does it take me to get my work permit after I do biometrics in September? So it's hard to say when the work permit is going to come after the biometrics because it's all over the place. And it depends on what type of application you're filing for. If it's family based, you could get it in 3 to 6 months. If it's VAWA, for example, then you could be getting it in 12 up to 12 months. So 6 to 12 months. VAWA case, C9 category, work permit and AP issues from NBC or VSC. So whenever it comes down to the work permit and AP, you'll see the National Benefits Center. Keep in mind that you're not necessarily going to be seeing things coming from the VSC. So that's the Vermont Service Center. And that's because they have now designated another service center. I believe it's Nebraska now, to help divvy up the workload. So you might be seeing things coming from the Nebraska Service Center now. Um, all right, so I'm going to quickly go through these questions. Okay. Can your spouse file for you if he's not working? Yes, that's possible. You do have to think about the affidavit of support. That's the main concern when the petitioner isn't working. And if they're not working, do they have assets to show that they can still meet the income requirements? If they don't have assets like a home or any valuable assets that could amount to there's a special formula used for that. But if they don't, then a co-sponsor has to be used. He lost his job in October 2022 and haven't gotten a job since. So it doesn't mean that you can't qualify, but you'll have to think about the affidavit of support and get a co-sponsor. Anybody could be a co-sponsor as long as they meet the income requirements. Um, all right. So that's going to be it for me today. Thanks so much for joining me. Thanks for your time. I am going to be back tomorrow. So I had a very busy week last week traveling to support my clients while we worked on their case. I am back, and so I do anticipate a more regular schedule. So I will see you tomorrow at lunchtime at noon. I aim to come on here at noon to be able to answer your immigration questions. I see one more. So after the I-130 case gets approved, how long does the rest of the process take from the NVC? So you could be looking at anywhere from 1 to 2 years, 1.5 years to wait for an interview. Um, Absolutely. So, CNOC's mom, absolutely. I am in Florida, but as a U.S. immigration attorney, I represent my clients all over the country and the globe. I have clients in the Caribbean. I have clients in Africa. I have clients in South America. I have clients in, Europe. So I have clients in Canada. So I have clients all over the world. And the distance has never been a problem. I do travel when my clients do need me and they want me there or they need me there. I do travel around the country. So we are very used to working from a distance for our clients because no, when you're in one place, the USCIS offices that you have to work with, the immigration courts that you have to work with, they are all over the country. So even though you may be in New York, you probably will be filing your application in a different state. And because of that, we immigration attorneys are allowed to practice wide. So go ahead, schedule the consultation. The phone lines are open. Go to the link in the profile. You will see on YouTube, you'll see everything you need on the bottom of the screen. You'll see the phone number. You can also description of the video and you'll see the link. You can schedule your own appointment. You can call and speak to a scheduling coordinator who will be more than happy to speak with you and assist you with your matter and assist you to schedule the consultation, right? So we can talk. So go ahead, anything that's immigration related, I can help you with. Go ahead, call, schedule the appointment, and we can talk. All right. Have a great day, everyone. I'll see you tomorrow. Bye bye.